Hello everybody, I'm George from Ireland. So now on the English Law Channel I'm going to look at leases. And first of all, what is a lease? Well, if an estate in land gives the owner of that estate the exclusive, if someone has an estate in land, then the owner has exclusive possession. There are two kinds of estate in land that can exist at law. There's fee simple and term of years absolute. So the term of years is a lease. It could be many, many years, could be centuries, and that's carved out of the greater estate, as in the absolute owner owns it for eternity, and he's giving somebody lease for 50 years or for 6 months or whatever it is. So the land is owned by the fee simple owner. This is the landlord. He's the lessor. In the case of leases, he's leasing it out to another. He's granting a lease to the tenant or the lessee, as we sometimes say. So lessor is active, lessee is passive. So the lease of land means there are proprietary rights and contractual rights for the landlord, but also for the tenant. So there are pressures on both sides here. Now, this is made even trickier by the lease's commercial importance and the broad range of transactions that it takes in. So the tenant is the owner of an estate in land, even though it's not the absolute owner of the land. He owns it for a limited period of time. That could be a very, very long time. And there are certain limitations on this. But there's a consumer contracting for the provision of services. The lessee is. So it's even more complicated because there's tension here between the contractual nature of the lease and its proprietary nature. Look at Bruton against Lloyd Quadrant Housing Trust 2000. And the court upheld the existence of contractual non-proprietary leases. The reason for the decision in Bruton was the tenant needed to be defined as a tenant so that he could come under the statutory provisions of the rights of tenants. And the judiciary was not trying to overturn the centuries-old doctrine of leases. It shows that there are certain restricted rights for the person who has a license. Anyway, I want it to be easy to understand. A lease or term of years is exclusive possession of the land for that time, for that number of years. So Lord Templeman set out the criteria for a proper lease in Street and Roundford in 1985, and he said that it is tripartite. 1, there is exclusive possession. 2, it's for a fixed term, and 3, there must be rent, or else just payment once off, but there must be some sort of payment. So a lease in land is a legal estate in land as per section 1.1b of the LPA 1925. A term of years absolute in possession. So we say term of years, but it could be a term of months. It's still a lease. So there's exclusive possession. So Lord Templeman in Street and Mountford went on to say this is the right to exclude others, and that includes the landlord. The landlord has rather restricted rights about when he can come in, look at the property, inspect it, and so on, has to give notice, has to seek permission. So the lease might provide for him to come in at certain times or under certain situations. The landlord doesn't have an automatic right. So that was one of the factors that the courts will look at if they're trying to say, is this a lease or a license? There's also a fixed term. There's a maximum number of years or months it could last. However, there are some exemptions to that, and statute has reformed this. Now, the lease could be set right at the beginning, or could be a periodic tenancy renewing every year or something. So either party can bring this to an end. So the maximum term for the lease is not set at the outset, but the successive terms of right to exclude are crystal clear. So look at rent. Now, that's not an essential condition of a lease, as per sections 205X of the Law Property Act. Look at Ashburn Anstalt against Arnold. But almost every single lease will say, you have to pay some money. Periodic tenant's duration is monthly, and it can be quantified on a monthly basis because the rent is paid every month. So remember, there's going to be a capable grantor, someone who has proper title to the land, who's has got capacity, and a capable grantee. So the person who creates the lease has to have a greater estate in land than the person he's granting it to. A fee simple owner could create a lease, a 99-year lease. The tenant could then have a subtenant and give a 60-year lease to somebody else. And the subtenant could have a sub-subtenant and give that person a 20-year lease, for instance. So each lease is taken out of the longer lease. But you can't, if you have a 60-year lease, you can't give someone a 61-year lease because that's going beyond your time. Okay. All right. So other things to think about. So Bruton and Quadrant Housing was a really important case here. So a housing association was a licensee of the property, but they didn't have an estate out of which they could grant a lease, as in a proprietary estate in land. So a lessee can grant a sublease, but a licensee cannot. The housing association gives someone the exclusive right to occupy the property, but this person then sought the protection of a statutory provision, which is applicable only to tenants. The House of Lords said that X had a non-proprietary lease and was a tenant of the property. So exclusive possession. Anyway, there's a leading case here. Street and Mountford said the court will look for what the real bargain is, and the court will disregard shams. So if a document says that it's a license, if it's not really a license, the court will say it's a lease. So landlords often try to call things a license because it gave them the greater rights and the tenants fewer rights. The courts will disregard that if they say that's not the real situation here. Remember, a lease must have exclusive possession, must be for some term of matters in amount of time, and there must be some rent. And there are lots of problems to consider in this area to see what the agreement is between the parties. And see that the territory is occupied by them. Anyway, so the House of Lords had some judgments on this one. The House of Lords heard AG Securities against Vaughan, as well as Antoniades against Villiers. Both came up in 1990, and these are very worthwhile looking at. These joint appeals were about different situations, and there were different results. So anyway, in Antoniades and Villiers, there was an unmarried couple, male, female, and they had a flat. It was a room in an attic, really, and the landlord, there was agreed that this was a license, but it was found by the House of Lords to actually be a lease because they said it was a sham. The landlord had said he had the right to spend the night in that bedroom with them. Now, surely that can't have been real. So, in reality, they had exclusive possession of the flat, so it was a lease. AG Securities against Vaughan was about a group of friends, not about some romantic couple, who were renting rooms in a 4-bedroom flat, which was rented out by a company. So each person had exclusive possession only of his bedroom, and of course they shared the kitchen and bathroom. But the 4 unities weren't there. Remember the 4 unities of time, title, interest, and possession. They'd moved in different times, not all the same day, and some people moved out. Someone else comes to replace him, and people swap bedroom. I'm the longest sitting person here, so the guy who'd vacated with the biggest bedroom, I'll move into that one, like that. So even though it was officially a lease, the court said in reality it's a license because of that. So you have to look at the facts of any case and compare them to either Vaughan or to Villiers. So there's also Street and Mountford, which we will have to look at. So there are other important cases such as Aslan and Murphy, 1990. So here the landowner had not kept exclusive possession in a residential occupation agreement. Said that the tenant had to go out for an hour and a half each day. The Court of Appeal said that's ridiculous and that's a sham, so we're just going to disregard that. On Mikeover and Brady in 1989, there were pals. They were not people in an intimate relationship, and they had to sign a separate agreement. So each person was responsible for paying half the rent. The same provision could be found in Antoniades and Villiers. Each occupant, despite being an intimate couple, was treated as having to pay half the rent. In Antoniades and Villiers, this was regarded as a nonsense, and the court said doesn't count. In Mikeover and Brady, it was found that because these two were not boyfriend and girlfriend, that this was a real provision, and it would be upheld. Anyway, So they were held not to have a lease actually, but separate licenses. So there's a small distinction here, and that's why the results were different. So an occupier who doesn't have exclusive possession is not a tenant, can only be a licensee. So if an occupier does have exclusive possession, that doesn't automatically make him a tenant. He could still be a licensee. For example, look at a hotel room, and yes, you've got exclusive possession, I suppose, for 24 hours or more, though they might go in to clean it without your permission. But you're going to be there alone for a stay. Nobody's allowed into that bedroom unless you invite them in. So supposing you paid for your hotel room and then somebody else and another guest was put there without your permission by the hotel, you'd find that unacceptable. So got to say it's a property right or a personal right. It's just a personal right to be in a hotel room. Okay, in Street and Mountford, an occupier is granted exclusive possession of a residential accommodation for a fixed period at a stated rent. It seems to be a tenancy. So there be extraordinary situations when the court will say, despite all that, it's not a tenancy. Marcroft, Wagons and Smith, 1951, they were just friends. It was informal. David and Lewisham, 1977, it was a family situation. Paying some rent towards your parents. Or an employee, Norris and Checksfield, 1991. Or lodgings where they cleaned your room for you, like Marchand and Charles, 1977. Remember, Mike over and Brady, the crucial thing there was each person was responsible for paying his or her own rent. That's enough for me. Toodaloo.